Please subscribe, like and share this content. It means a lot to us. Thank you in advance. Cornell Law School. U.C.C. Article 9. Secured Transactions. Part 1. General Provisions. Subpart 1. Short title, Definitions, and General Concepts. Paragraph 9-103. Purchase money security interest. Application of payments. Burden of establishing. A. Definitions. In this section, 1. Purchase money collateral means goods or software that secures a purchase money obligation incurred with respect to the collateral, and 2. Purchase money obligation means an obligation of an obliger incurred as all or part of the price of the collateral or for value given to enable the debtor to acquire rights in or the use of the collateral if the value is in fact so used. B. Purchase money security interest in goods. A security interest in goods is a purchase money security interest, 1. To the extent that the goods are purchase money collateral with respect to that security interest. 2. If the security interest is in inventory, that is or was purchase money collateral, also to the extent that the security interest secures a purchase money obligation incurred with respect to other inventory in which the secured party holds or held a purchase money security interest, and 3. Also to the extent that the security interest secures a purchase money obligation incurred with respect to software in which the secured party holds or held a purchase money security interest. C. Purchase money security interest in software. A security interest in software is a purchase money security interest to the extent that the security interest also secures a purchase money obligation incurred with respect to goods in which the secured party holds or held a purchase money security interest if 1. The debtor acquired its interest in the software in an integrated transaction in which it acquired an interest in the goods, and 2. The debtor acquired its interest in the software for the principal purpose of using the software in the goods. D. Consignor's inventory purchase money security interest. The security interest of a consignor in goods that are the subject of a consignment is a purchase money security interest in inventory. E. Application of payment in non-consumer goods transaction. In a transaction other than a consumer goods transaction, if the extent to which a security interest is a purchase money security interest depends on the application of a payment to a particular obligation, the payment must be applied, 1. In accordance with any reasonable method of application to which the parties agree, 2. In the absence of the parties' agreement to a reasonable method, in accordance with any intention of the obliger manifested at or before the time of payment, or 3. In the absence of an agreement to a reasonable method and a timely manifestation of the obliger's intention, in the following order: A. To obligations that are not secured, and B. If more than one obligation is secured, to obligations secured by purchase money security interests in the order in which those obligations were incurred. F. No loss of status of purchase money security interest in non-consumer goods transaction. In a transaction other than a consumer goods transaction, a purchase money security interest does not lose its status as such, even if 1. The purchase money collateral also secures an obligation that is not a purchase money obligation. 2. Collateral that is not purchase money collateral also secures the purchase money obligation. Or 3. The purchase money obligation has been renewed, refinanced, consolidated, or restructured. G. Burden of proof in non-consumer goods transaction. In a transaction other than a consumer goods transaction, a secured party claiming a purchase money security interest has the burden of establishing the extent to which the security interest is a purchase money security interest. H. Non-consumer goods transactions. No inference. The limitation of the rules in subsections E, F, and G to transactions other than consumer goods transactions is intended to leave to the court the determination of the proper rules in consumer goods transactions. The court may not infer from that limitation the nature of the proper rule in consumer goods transactions and may continue to apply established approaches. Paragraph 9-104. Control of deposit account. A. Requirements for control. A secured party has control of a deposit account if 1. The secured party is the bank with which the deposit account is maintained. 2. The debtor, secured party, and bank have agreed in an authenticated record that the bank will comply with instructions originated by the secured party directing disposition of the funds in the deposit account without further consent by the debtor. Or 3. The secured party becomes the bank's customer with respect to the deposit account. B. Debtor's right to direct disposition. A secured party that has satisfied subsection A has control, even if the debtor retains the right to direct the disposition of funds from the deposit account. Paragraph 9-105. Control of electronic chattel paper. A. General rule. Control of electronic chattel paper. A secured party has control of electronic chattel paper if a system employed for evidencing the transfer of interest in the chattel paper reliably establishes the secured party as the person to which the chattel paper was assigned. B. Specific facts giving control. A system satisfies subsection A if the record or records comprising the chattel paper are created, stored, and assigned in such a manner that 1. A single authoritative copy of the record or records exists which is unique, identifiable and, except as otherwise provided in paragraphs 4, 5, and 6, unalterable. 2. The authoritative copy identifies the secured party as the assignee of the record or records. 3. The authoritative copy is communicated to and maintained by the secured party or its designated custodian. 4. Copies or amendments that add or change an identified assignee of the authoritative copy can be made only with the consent of the secured party. 5. Each copy of the authoritative copy and any copy of a copy is readily identifiable as a copy that is not the authoritative copy. And 6. Any amendment of the authoritative copy is readily identifiable as authorized or unauthorized. Paragraph 9-106. Control of investment property. A. Control under Section 8-106. A person has control of a certificated security, uncertificated security, or security entitlement as provided in Section 8-106. B. Control of commodity contract. A secured party has control of a commodity contract if 1. The secured party is the commodity intermediary with which the commodity contract is carried, or 2. The commodity customer, secured party, and commodity intermediary have agreed that the commodity intermediary will apply any value distributed on account of the commodity contract as directed by the secured party without further consent by the commodity customer. C. Effect of control of securities account or commodity account. A secured party having control of all security entitlements or commodity contracts carried in a securities account or commodity account has control over the securities account or commodity account. Paragraph 9-107. Control of letter of credit right. A secured party has control of a letter of credit right to the extent of any right to payment or performance by the issuer or any nominated person if the issuer or nominated person has consented to an assignment of proceeds of the letter of credit under Section 5-114(c) or otherwise applicable law or practice. Paragraph 9-108. Sufficiency of description. A. Sufficiency of description. Except as otherwise provided in subsections C, D, and E, a description of personal or real property is sufficient, whether or not it is specific, if it reasonably identifies what is described. B. Examples of reasonable identification. Except as otherwise provided in subsection D, a description of collateral reasonably identifies the collateral if it identifies the collateral by 1. Specific listing, 2. Category, 3. Except as otherwise provided in subsection E, a type of collateral defined in the Uniform Commercial Code, 4. Quantity, 5. Computational or allocational formula or procedure, or 6. Except as otherwise provided in subsection C, any other method, if the identity of the collateral is objectively determinable. C. Supergeneric description not sufficient. A description of collateral as all the debtor's assets or all the debtor's personal property or using words of similar import does not reasonably identify the collateral. D. Investment property. Except as otherwise provided in subsection E, A description of a security entitlement, securities account, or commodity account is sufficient if it describes 1. The collateral by those terms or as investment property, or 2. The underlying financial asset or commodity contract. When description by type insufficient. A description only by type of collateral defined in the Uniform Commercial Code is an insufficient description of 1. A commercial tort claim, or 2. In a consumer transaction, consumer goods, a security entitlement, a securities account, or a commodity account.